It's not about what you know or even how you think, but how you say it. Hi, and welcome to the Law Simplified, the world's largest independent online law school platform. I'm your instructor, Shaveen Bandaranaike. I have said on this very YouTube channel, as well as the different platforms the Law Simplified is disseminated on, that a law degree is not just about what you know, but how you think. I'm going to qualify that slightly in this video and supplement it to some extent by also proposing to you that not only is it about how you think, but how you say it as well. If you like the type of content that I make on this YouTube channel, do subscribe to the Law Simplified and leave a comment below of what other types of content you'd like to see. If you are a first, second or third year law student, I would highly recommend enrolling in the comprehensive online law school platform, complete with theory, tutorial and workshop lessons based on the actual one-on-ones that I have conducted with first-class law students globally. So, how exactly should you change or perhaps rethink the way that you say something to an examiner? The process that I want to impress on you, and you can take this from the perspective of a problem-based question or even an essay-based question or a theoretical question, is to layer your responses. What do I mean by this? Essentially, any response has three components, namely the law, the facts, and yourself, which is essentially the arguments or your personality. Now, on a number of different occasions, I have tried to impress upon my own fast track and masterclass students, as well as those of you who have watched these videos on YouTube, that you really have to develop your own personality in terms of a law student. This personality is what will come through your responses, because after all, from an examination context, you're going to be a student number if at all. It's anonymous, and how you're going to differentiate yourself from someone else is to make sure the examiner is aware of your temperament. The fact that you're pragmatic, the fact that you're objective, and that you're knowledgeable is essentially quite important, not just from the perspective of your grade, but also in context of the overall qualification itself and the later profession. So, how do we layer our responses? First of all, you have to use the law to build your foundation. What do I mean by this? Essentially, the law that you use, whether it be common law or precedent case law or statutory provisions, essentially amounts to the rules of the game. This is what would be used in relation to your overall argument later on. So there is a framework, there is a ring fencing, so to speak, that's present that you have to work within. This limitation is what differentiates the good students from the great, and your ability to weave as many resources in terms of the knowledge that you have really elevates your response. Secondly, use the facts to give context. Now, the scenario that you have been presented, or in terms of a theoretical question, the prompt to critically analyze, that's the framework by which you are going to apply the law. Now, you would have heard your examiners tell you ad nauseum that you are lacking the mark or the grade that you deserve because you haven't applied the law. This is what they mean from that. The fact that you are going to show the examiner that you are aware of the necessary law and a wide gamut of that, but in context to the facts being presented. That you use only the relevant law for the relevant facts, and you are able to surface its application through making sure unique perspectives are being shown, which brings us to the third aspect of layering your responses. Finally, you have to use your arguments to establish depth of your response. Most answers without arguments, without critical analysis, it's very superficial. And what I mean by that is you have identified the relevant law, you have surfaced the relevant facts to that law and applied it to some extent perhaps by connecting the facts to similar case law or provisions that really outline the issue at hand. But you haven't brought out arguments, you haven't looked at the pros and the cons, you haven't identified the fundamental issues to be tackled, you haven't even considered and acknowledged what the examiner is trying to get out of you. Now, in a previous video, quite recently on this YouTube channel, which you can access through the description or the pop-up banner that will appear on top, I've tried to impress upon you why it's important to negotiate with your examiner on the one hand, and to show the examiner that you appreciate and you acknowledge what they were trying to test you on. This is not just to say that I've identified that this case or this provision matches this fact, but thinking a bit deeper and trying to acknowledge and recognize this is the principle of law, the fundamental issue that the examiner wanted me to see. Right. Layering your responses in law is really about building a foundation with the law itself, providing context with the facts, and then showcasing your depth through your arguments. With these three aspects in place, whether it be a problem-based question or an essay, you're not just going to pass your examinations, but you're going to impress your examiners by acing it all together. That being said, until the next time that we speak, have fun, stay safe, and as always, obey the law.